All right, I think we're just about ready to get started here. Good morning to everyone, wherever you are all over the world, whether you're in the room or whether you're here in spirit and following us online. Let folks know. This is our CALIC event, Community and Legal Issues Clinic. This is our third one. We try to do them quarterly. It's important for us to give information that affects folks in the community, legal issues as well as things that connect to legal issues, okay? That's why we always do it. So the first thing that we're gonna do is we're gonna hear from our distinguished host. And I love all our hosts, but anytime your host is actually your pastor too, that's a little bit of a bonus. So I wanna bring up to start us off our pastor and local entrepreneur and all around good guy, Pastor Frank Oliver. Come on, Pastor Frank.
Hello, everyone. I am excited that you are here. I was feeling some type of way when we call him here Elder Joseph. He's a ordained minister of the gospel here, but I was a little offended. He was at all the churches. I'm like, bro, what's going on, you know? And so I'm glad that he is here and he knows he can utilize this space anytime as he's doing the Lord's work. To his wonderful team, to everyone who is here, all those who are going to watch online, I just think that this is just a God move, and you should really be in tuned and let everyone know of what is happening, what is occurring, the shifts that are happening, and to watch God merge again faith and faith and our legal system, and to merge them to make transformational change. And to many of us as preachers here in the IE, we're really wanting it to knock out the stigma of the separation of church and state, the separation of the secular and the sacred. Paul gives us this merger, this intersection of where our lawyers and our preachers meet in the book of Titus. Chapter number 3, Paul, as he's talking to Titus, one of his spiritual sons, he ends, I always watch some of the final things a father would say to their child, the final things that one would say when you would leave out. Some of those are the strongest things. Those are the things that kept me out of trouble when I was younger, to listen to the final things before I left going to the party, listen to the final things before I left. There was a list of things that my grandfather would tell me to make sure that I've done, and so I've taken that approach in the scripture to really pay attention to Paul's final things that he said to Titus. And part of it said, Titus, I need 2 people that you need to bring, and they need to hurry up and come. He said, I need you to bring Zenas, the lawyer, and Apollos, the preacher. They need to come and see me soon. And it kind of reminds me of how we feel when we call our lawyer when we get in trouble. It's like, I need you now. I need you to come now. I feel it's also, as being a preacher for over 30 years, is when people call, they tend to call me in urgency. I need you now. And it is in that intersection that Paul shows us that here is this lawyer who he needs to help build and help defend. And here is this preacher named Apollos who he needs to help pray and help in the faith. And I believe that what we're seeing now is that intersection happen again, where we have our legal experts and our legal teams intersecting with many of our sacred and faith communities to bring that intersection that people's lives might be changed and transformed. And so I implore you, I beg those who are here and those who are watching to really tune in, to really hear what is being said, to really look and see what is being offered. Let us change our mind. Let us shift our thinking from not being reactionary when it comes to anything that has to deal with us legally or has to deal. Let's be proactive, right? Let's be in the place of having an engaging conversation with people so we can avoid the pitfalls and we can avoid getting in the problems and the dilemma. And let us begin to kind of engage and understand what is going on in our world, what's going on around us, and how systems and how laws are being are drafted, are being enforced, are working, and how do we understand those for the benefit of our communities. And so I am excited, always excited every quarter of what is happening, what is being done. I'll say this caveat, of most people, the information you're going to get in these seminars, most of us don't even have enough money to pay for this. You don't have enough money to pay for this. I don't know if some of the young men in our congregation get in trouble post-COVID, and they realize the retainer of the lawyer, it ain't no joke no more. The lawyer got to pay their bills too, and so instead of feeling like you can't afford it, I think that God has opened up a great door of you getting great information, you getting to hear what is really going on, what is really hearing from experts. The second thing I'll say, and then I'll get out your way, is these experts that you will hear from are not Facebook attorneys. They're not Google. They're not Google legal authorities. They got real weight. They got real weight. They know they stuff. I remember when one of my uncles was in jail. He said he was telling me how he was gonna get out, how he was gonna beat the case, and I said, "Who you been talking to?" He said, "I've been talking to my guy. He's an attorney." I said, "He's locked up with you too?" I said, "I wouldn't take his advice." I said, "He in there with you?" I wouldn't take his advice. And so what has happened is we have a lot of people who feel that they know the law. They become Facebook experts. They become social media experts, and they are not those who have practiced, those who are really involved and engaged in their field. Today we have those who are tried and true, who are going to give you information that it be accurate information that they care about, and there are those who have really taken their oath and taken their profession serious. So let us please make sure we tune in, make sure we listen, and let us make sure we let others know what is happening and what great information and great wealth this is. The last thing is the Inland Empire. We have always sometimes been treated as the stepchild to the LA. Everybody thinks what LA got going on. I want to tell you, we have great wealth, we have great resources, and we have great people who are here in the Inland Empire doing great things, and we want to highlight them and let us support and build our own. At this time, I'm bringing up the guru himself. He does it, everything he does well. He's the speaker, he's the lawyer, he's the fighter, he's a superhero to me. Put your hands together if you can for Joseph Richardson.
So I'll quickly say that he reminds me of this episode of Sanford and Son. And one of the things that I'm thinking about, some of you will connect to this. If you remember the show, The Jeffersons, for 227. I was actually at my 6th grade teacher's funeral last week, and she's very close to Marla Gibbs, who's 90 years old, still alive. Sarah, she's sitting right behind me. So I was watching years ago this episode of Sanford and Son, and this guy is talking to Fred Sanford and telling him, this guy, he's fantastic. He really knows his stuff. He's really a great legal mind. So they have him come over, and he starts telling him things about how to help him with his problem or whatever else. And Fred's son, maybe Damon Wilson, asked him. He says, "So you're a lawyer?" And the guy says, "Well, that depends on who you ask." So the son asked him, "So, well, who would say you're not a lawyer?" And his answer was, "The state of California." Okay, so that's probably not what we want to do. But in any event, let me preview quickly who our speakers are going to be today. Frank Oliver, you'll see him more. I'm going to be talking about vaccinations in the workplace. Kimberly Lewis of Pro Se Legal is going to be speaking. We're going to go change the order a bit. Lynnae Palmer is going to speak and talk about her wonderful business dealing with elder care, memory care, and those types of things in a very personal, hands-on kind of way. They're going to speak one after the other because there's a connection between them. And then attorney Brad Baldwin and Linda Jackson of the Inland Empire Resource Center are going to speak, again, the carrot and the stick related to landlord-tenant issues, what's happened with the moratoriums, and those type of things. Okay, so that's where we're going to go. So let folks know. We also think, we know this will be, I want to shout out our marketing department, Devin and Sammy and Ricky and everyone who's helped put this together, like always very high level professional stuff where this can be broadcast to the world, and it will be a standalone product that people can call on demand at any time. All right, so I wanted to speak briefly, if I could, about, I don't know if I'd say it's the elephant in the room, but everybody seems to have a question about it. I have been getting a lot of calls on the phone from employers and employees related to COVID vaccinations and mandates. Can they make me? Or can we make them? All right? Or can I do it in a way, some employers have asked, can I do it in a way where I'm not upsetting anyone that doesn't necessarily want to get a vaccination and those types of things? So we're going to talk a little bit about vaccinations, all right, and in terms of where the law is. And I've actually gotten some good revelation recently about where the law is, even though I have said before that it's fluid. The fluidity comes from the fact that there are a lot of lawsuits related to it, and that's where the fluidity comes from. But as a general statement, I'll go back to go forward. It's probably been close to a year ago. There was an EEOC general ruling, which didn't necessarily have the force of law, but pointed into a direction that basically said that employers can require mandates, can require vaccinations, can require folks to be vaccinated. Okay. And so as we went along here and the vaccination came out and became available to more people where people could get it, et cetera, the question became, well, what is the federal government going to do? Because a lot of times we follow what's happening with the federal government, and that kind of filters down. So the first thing President Biden did was he required it for certain departments in the federal government, for federal government employees. And then the next thing that happened was that he issued an order that it would be required for companies that had over 100 employees. And I think it's without an exception. I don't want to get that wrong, but basically as a general statement that it would be required for companies over, private companies over 100 people. So thus far, we've seen, and it changes every day because it seems like there's a lawsuit filed every day. But we've seen about 20 to 25 cases so far all over the country, all different jurisdictions. And as a general statement, despite the style of the judge, despite the venue, despite the political leanings, if you take one from who has appointed the judge, thus far, vaccination requirements and mandates in the workplace are being upheld. Vaccination requirements by entities, cities, et cetera, have been upheld, okay? The caveat is that the biggest exception that we've seen, and there is some fluidity there as well, has been religious objections. That's been the biggest one. So I've had several people call me and say, they're discriminating against me. Can they do it? And I have answered in a very measured way. So as to say, well, it's kind of fluid, and we haven't been here before quite this way, but we kind of have, at least in terms of having a circumstance where someone tried to keep from being vaccinated. So, Brad Baldwin's going to speak later, and he's a great young attorney. He's actually in my class. I almost didn't say that because I didn't want to date him, but what really is the real deal, I don't want to date me. I'm like twice his age. But I was sitting talking to him, and I said, yeah, as it turns out, there's this case that's 100 years old, and basically it says that there's no fundamental right to refuse to be vaccinated. He's like, oh, yeah, the Massachusetts case. I'm like, kid already knows it. So in any event, I didn't know it. So, I missed that day of class 25 years ago. So basically, there's a case called Jacobson versus Massachusetts, and it actually goes back to 1905. And it was about smallpox and someone that did not want to get vaccinated. And the court basically has said, and several of these recent cases that have been filed have cited this case, because most of the time what you're going to do in a case like this, you're filing in order to keep a vaccination mandate from going into play or from continuing to be executed. And so what you're asking for is injunctive relief right away. In other words, you want to stop the clock while this is all dealt with. So they're getting in front of the judges right away because they're trying to stop the practice. And several of them have cited this case and basically said that there is no fundamental right to refuse to be vaccinated. So depending on who you are, maybe that's good news for you, or maybe that's bad news for you, but it is what it is. Here's a couple examples. There was a federal appeals court, and this is about a week ago, in the state of Maine, that said that that the state can enforce its vaccination requirement for healthcare workers. The first U.S. Circuit Court of Appeals said the governor had no choice but to mandate that healthcare workers be vaccinated to curb transmission of the Delta variant. All right. The opinion also says, and this kind of gives you a little bit of an inkling as well as to where the courts are coming from or what might be said about these cases. It noted that the state resorted to tougher measures just as a last resort. So they tried to carrot. They tried to incentivize. They tried to pay people money. They tried to, give them different things or whatever the case may be. But that failed to persuade enough people to get there, all right? So there's another case in Massachusetts where a federal judge, this is about a week ago as well, refused to halt the governor's requirement that state executive branch employees show proof of vaccination as a condition of employment, okay? So that's coming out, and you're seeing that, in a lot of different places, all right? There have been several folks that have tried different lawsuits to stop the Oregon governor. I have a dear friend who is a mayor in Oregon. Shout out to my good friend Jules Walters. They have rejected efforts that the judges have thus far to stop the Oregon governor from requiring state employees, teachers, school staff, and medical workers to be vaccinated. In one case, a group of paramedics, teachers, nurses, and other plaintiffs said they had a fundamental right not to be coerced by the state of Oregon to be injected with an experimental medication. The district judge disputed the plaintiff's characterization of the policy as a forced medical experiment, stating that the mRNA vaccines developed to fight COVID-19 had undergone significant clinical trials and safety evaluation by the US FDA. So we get a lot into the gray area, whether it's experimental, whether this platform can be trusted and things like that. And so you're seeing a myriad of arguments that way in order to stop the vaccination mandates. Thus far, and we will see, because we got a different kind of Supreme Court right now, and we will see what happens, but thus far, they've recognized that a state can basically use its power to require someone to be mandated, to require them to be vaccinated, okay? And in fact, the Oregon case, the judge said Jacobson, which is the Jacobson versus Massachusetts case. Brad Baldwin knew that I didn't, okay, established there's no fundamental right to refuse vaccination. And that case goes back to 1905, okay? So it's clear that right now, vaccination mandates are coming down, and thus far, they have been supported by the courts, thus far. Okay, it's unclear how much leeway states are gonna have to impose health orders against religious objections. So, I'm not trying to tell you to get religious if you haven't been, because I don't think you can necessarily fool God. But, depending on how you approach this thing, right now it seems like the exceptions are connected to religious. Many people will, many employers are saying mandate or test, okay? And regularly test. I've had people answer and say, well, that's discriminatory because they're forcing me to test just because of my status. And by the way, I'm jumping around a little bit. There's a couple questions that you want to answer. Does your status have to be revealed to your employer? The short answer is yes, because there is a scenario under which it could be relevant to the safety of people around you and the safety of the people you serve. The reason for your vaccination status is not necessarily to be revealed, because your vaccination status might have to do with a disability. And now you get into HIPAA, and now you get into all these other things. And so what employers have to be careful about and what employees have to be aware about is that even if there is a requirement to say what your status is, the reason for the status is not necessarily required to be revealed. And so therefore, employee, if you have anything you don't want your employer to know about your health other than your vaccination status, you make sure that what you give them just reveals the vaccination status. And so therefore, it shouldn't say not vaccinated because of disability, not vaccinated because of this, or vaccinated because of this or that and the other. So you should be able to keep the things that are private, okay? And by the way, BTW, IJS, what the kids like to say, if there is any adverse action related to those discussions, an employer has to be worried and concerned or careful about making sure that there's no adverse action against that employee after you've had that discussion, because you can still be on the hook for discriminating against your employee for disability if you had that discussion, if you didn't. If you happen to fire somebody a week after you have a discussion about the vaccination, you have to be concerned about whether or not they might be able to have a particular cause of action related to that adverse action being because they're in a they're in a protected category. That could be disability, it could be race, it could be any of those things. So even though there is maybe a requirement to vaccinate that people bring down, and I'm going to talk about this is what you must do, I'm talking about what may you do in a second. Even though there could be that requirement, you still have to be very careful, because depending on how that conversation goes, there could potentially be legal liability. Now, let's talk about, I talked about, I think exhaustively enough, what must happen, but let's talk about what can happen as a practical matter. What we are hoping is that employers and employees are getting together and problem solving in the best way they possibly can, related to having a safe workplace where the job is getting done, et cetera. And so therefore, it is in play that an employer can and maybe should consider an accommodation that alleviates the issue that is surrounding the vaccination. So if someone can actually work from home and they've proved productive doing so, et cetera, I have said before that up to this point, working from home has not been a favored accommodation under the law, because back in the old school, the thinking was you're not as productive when you're at home, okay? That has not been a favored accommodation. So they don't have a right to accommodate you because you don't want to be at the workplace because of COVID or because you have someone sick at home. But if the work potentially allows you to do that, then perhaps that is cause for a discussion about whether there'll be an accommodation in a good faith interactive process. So this is just COVID, and what happens with COVID is another cause for a discussion about the practicalities of how work will get done. So that doesn't mean that you can't work from home. It might not be required that they make you work from home. And the next thing that you have to remember, by the way, is that there are instances in which two employers may have an employee that's requesting the same accommodation, but one employer would have too much of an undue hardship in providing that accommodation. It could be totally reasonable. It could be totally reasonable for you to be able to work at home. But if the work doesn't require that, if the work doesn't allow that, if half to 3/4 of what you did had to do with being part of the presentation at the office, then that can be a potential issue. So from employer to employer, whether something is reasonable is a separate question as to whether or not that employer actually has to do that accommodation. So hopefully you are building on a good employee-employer relationship where there's value and mutual respect. And so then there becomes a discussion about what can you do, even despite what's required, what can be required, and what your rights may be. So it doesn't have to be bad news in and of itself that there is a vaccination requirement, because there could be testing. And by the way, I tell employers that will listen to me that if you're small enough and you have the resources to do it, consider testing everyone regardless of vaccination status. Because it does a couple things. First of all, I think it's good data to have. That's thing one. And thing two, it takes away the feeling that some folks have that they're being discriminated against and singled out because they have to test just because they're not vaccinated. Now, that might not be possible for larger employers, but for smaller employers, that might be something for folks to think about, okay? So at the same time, the other thing I meant to mention as part of our rules of the road, people that are watching can submit questions, okay? And so as we go along here, we'll take some opportunities to answer questions to the extent that we can. Let me jump just for a moment, and then I'm gonna bring up my next person about things that we look for in our department. This program is part of what the Racial and Economic Justice Department does at our firm. And racial economic justice is really meant to help people with income and wealth disparity, particularly people of color, even though I help people that aren't people of color too. I've done it all my career, and I continue to. We look for wrongs to right, and we try to right them, okay? And so, what does that mean? What that means is that you have a resource, a community resource that can listen to you and help you with issues related to, could be employment issues, could be civil rights issues, could be consumer class action issues. So any area in which, as a consumer, our firm's job is actually to provide everything for the consumer, just like a big defense firm or corporate law firm provides everything for the business owner. So there's a personal injury department headed by our colleague, Corey Weck. There is an appellate department. There is a business litigation department, and I'm racial and economic justice, and a lot of times there's crossover between the work that we do. We really operate as a team. We roll pretty deep. We've got, 6 or 7 offices nationwide thus far, and we're planning quite a bit in the way of growth. Let me tell you what I'm looking for now. In terms of a profile of cases that I have, at any given time, I might have several police brutality cases. I might have cases regarding the treatment of students in school districts. I might have cases regarding the treatment of employees in workplaces that are both private and public, including school districts. I might have cases that are related to treatment of people that go into stores that are people of color that have things go on in the store, being targeted, having the police called on them, those types of things, okay? On the employment side, the case that I am looking for, just so you know, tell a friend, like Alpha Beta. Anybody remember Alpha Beta? Tell a friend, Alpha Beta. Anyway, the case that I'm looking for is a case where someone in a protected category, women, people of color, whatever the case may be, company-wide is not being advanced and getting over a certain level. Because what we're looking for are opportunities to really change things in places where there are glass ceilings for people that don't make logical sense, okay? And so if you feel a sense of unfairness in what it is that's going on with you. And I will let you know, sometimes things are morally wrong, but not necessarily legally wrong. Okay? The best of worlds is when what is morally wrong or ethically wrong catches up with what's legally wrong and it influences policy. I'll tell someone in a second. I had a conversation with a guy just the other day, and he's gonna end up being a friend because we're about the same age, we're from the same community and everything, even while I rejected his case. He had a situation where he was treated a certain way at the airport. And I said, I think it's race too. I really do. I think it, like, deep down in here. I won't prove it. Ever in life. Okay? And so therefore, here's our choice. You know, how do we go forward? So I might have to tell you that, and sometimes even an employee case where we think there might be a racial implication. Well, if there's a public policy implication, that might actually be at the front, okay? I look to remedy wrongs. We want to remedy wrongs. We want to remedy egregious wrongs. I am not interested, and I say this every time I speak, I am not interested in gotcha moments. Not interested in technical gotcha moments where you have a good employer that has made a mistake. I don't really want that case. Now, there are plenty of lawyers out there that do want it, and God bless them. But I don't want to put anybody out of business because they're a good employer and they didn't have an HR director and they forgot. In one case, I had this actually happen, and I've said this before. It was an $80,000 mistake. Guy did a private ballot, secret ballot, which is what you're supposed to when you want people to go in to vote on a alternative work schedule. They voted for it overwhelmingly. Somebody who got fired twice, no good deed goes unpunished category. Second time she got fired, she went and found a lawyer. And the lawyer brought the technicality that my person knew to do a private ballot, but he didn't know to file it with the state. $80,000 mistake. I would never have brought that case as a plaintiff, just so you know. So for those of you out there, you like the technicalities, you want to stick it to them like they stuck it to you, whatever else, I'm not your dude. If it's a case where something egregious is happening that shouldn't be happening, and we actually have a chance to correct something going forward with someone that's not in the right place related to it. You've gotten fired because you spoke up about something that you thought was illegal. I've had people get fired after their check didn't show up, and the person says, well, you shouldn't be complaining about your check not showing up because we'll fire you. And he says, what? And they fire him. I mean, there's no excuse for that, okay? So I'm not in the technical gotcha moments. I want people to stay in business. I want businesses to stay in business. But I want employers and employees to honor each other. I want police to protect and serve, and I think most of them do. But when there's a problem with someone that shouldn't be, and they got a cooked case against them or whatever else, okay, yeah, well, we might need to get involved with that, all right. But our idea is always toward restoration, and sometimes part of restoration is financial compensation, and I have no qualms about telling you that, okay. So that's what we look for. I could say more. People can, of course, ask questions and things like that. I think that they can go on live and ask questions, and we will take some opportunities to answer those. I'll take a minute before I bring Kimberly up. Is anybody here, see, this is what happens when you come here, you can do this like right away. Does anybody here have any quick questions that they want to ask? It's okay if you don't, you know where I am. So here's what I'm going to do next. We're going to keep it rolling and keep it moving. My partner in crime, she's done all of the events. Every time I do an event, she does an event. Kimberly Lewis is very comfortable in the church and in the church environment, and she has dedicated herself to serving people not only in her church but in her work. And what Pro Se Legal does is absolutely incredible because they fill this huge chasm, this huge gap between do-it-yourself legal services and paying the attorney a fortune when you don't necessarily have to pay attorney a fortune. So, you know, she can show you better than I can tell you, so I'm going to bring her up. Let's have Kimberly Lewis from Pro Se Legal. Kimberly.
Good morning, God bless you. Joe's slightly taller than I am, so the mic has to be adjusted. My background is I am a degreed paralegal with about 16 years in the legal field, and I'm also, or I was the former public relations director for a non-denominational Pentecostal church. So I will not take off on this stage with the microphone. I will keep it very mellow today. But I want to talk about non-lawyer legal. Pro se legal is what we call a legal document assistant preparer business. We are all degreed paralegals, but the only way we can classify being a paralegal is if we're working under an attorney. So if we are independent, we are what we call legal document assistants. We are in between LegalZoom and I would say pro bono free legal work such as like legal aid. We help individuals like everybody here and online do those non-contested, non-contentious legal matters, such as probate. Family member passes away, not everybody has to hire an attorney to go ahead and to file and draft those documents, but maybe they don't know what to do, they would call us. Uncontested divorce. You know, you have two people that just say, hey, we can't get along, let's just go ahead and separate and just go on our merry way. We want those clients. Why? They don't need to hire an attorney and have $30,000 in a legal fees to go ahead and to finalize that divorce. Powers of attorneys. You know, right now I am really wanting to educate the community in the importance of having proper power of attorneys in place. We are all suffering in this health pandemic. Nobody knows what's going to happen. But to have a really good healthcare power of attorney, somebody who can make healthcare decisions on your behalf when you're unable to. And then not only that, a very well drafted power of attorney for finances. Same thing, when someone's not in a position to handle their affairs. That way you know somebody can go ahead and take care of your matters. Business just runs smoothly as it needs to. I'm going to share a couple stories with you, and I really appreciate the pastor talking about the relationship between lawyers and preachers. One of my other passions right now is estate planning. Everybody needs to set up or get their affairs in order, so to speak. Setting up an inheritance is in fact biblical. It goes all the way back to the Old Testament, to where the daughters of Jezebel, I believe, went ahead and they presented to the chief of the tribe that though he had no sons, they were the daughters and entitled to their father's inheritance. Setting up an estate plan is in fact biblical, but it also keeps the family out of probate. So I want to share some of the services that we at Pro Se Legal offer, and I also want to tell you some of the war stories on what happens when people handle items on their own. And I'm saving business formations for the last because that'll be my segue into our next speaker, who we formed a very important bond, but I really want to save that part for the last. So on estate planning, a lot of times people think, well, I don't have much, you know. I own a home, maybe I have $20,000 in the bank account, or maybe nothing in the bank account, you know, but I own a home, or I have some vehicles and I have some children. The sad thing is if you pass away without protecting those assets, that asset and those vehicles and bank accounts are going to go through court, which then ends up in probate. What happens then? You have court fees. You have filing fees, you have probate referee fees, then you have executor fees. So all of a sudden, that bank account that maybe had some money, or that house that had some value in it that you were hoping to leave to your family, has now been dwindled down because of all these excess fees. We had a client come into our office, actually call us about 2 weeks ago from Colorado. He had befriended his neighbor. His neighbor did not have any children. His neighbor went ahead and drafted a will, named him as the executor, and then also named him as the beneficiary. Unfortunately, all he drafted was a will. He didn't do the proper estate planning. The individual ended up in court, now in probate. So when the guy came to our office, the funny story that he had was that one of the judges here in San Bernardino had actually kicked him out of her courtroom and had said, this is the third time you have been in my courtroom with improperly drafted documents and without all of the requested information that we needed. You need to go get some legal help. I asked him, how did you even learn how to do the stuff that you did? He said, YouTube. So right there I knew that he had a problem and that he needed to come to our office so that way we could go ahead and help him. You know, so a lot of times people who don't have a lot of money tend to think, oh, I can go ahead and go on Google, and I appreciate Joe saying, you know, the like Google lawyer, but they could go on Google or on YouTube or even Facebook, as the pastor had said, and get legal advice from everybody. Unfortunately, we do immigration as well, and that's where we get a lot of misinformation. Well, my friend did it this way and they got their documents. My friend did it this way and they got their documents. But you know, everybody's story is different. Everybody's pathway is different. The way how one person comes to a place is very different than how another person came to a place. So even in life, you can't compare people's stories to each other, but you also can't compare people's legal path to the other person, you know? So that's where Pro Se Legal likes to come in to go ahead and to help our clients as well. We sit down, we listen to what you have to say. We listen to what the situation is, and then you tell us, this is what I want to happen. We make that outcome happen at an affordable cost to you. One of the things that I also want to talk about, and I'll go back to probate because that seems to have the most problems. We had a client, and I had shared this a couple months back, whose father passed away in 1994. They filed the paperwork for probate in 1994. We finalized that for them August 2021. So what should have been possibly a 18-month or maybe even 2-year transaction turned into this 20-plus year case. Why? Because they kept filing stuff wrong, and guess what? The court kept taking their filing fees, So finally they came to us. We filled out the proper paperwork, attached all of the exhibits that the court needed, case closed. It's those simple matters that people think they can handle on their own that tend to turn out and just keep spinning on down the road. One thing in particular, and I know that the pastor in this congregation is very forward-thinking and wanting to set up entrepreneurs or businesses. And a lot of times people think, hey, you know what, I have a great product, or I offer a great service. I want to go ahead and start my business. COVID happened, a lot of stuff shut down, and we saw a shift in the industry to where people were like, well, heck, if I'm working from home and stuck at home, I can go ahead and start doing business. All of a sudden, everybody had these DIY crafts, you know, everybody had all these other services, but it actually opened up a market for people to start establishing business contracts, LLCs, corporation, partnerships agreements, and so people were thinking they need to have an attorney to go ahead and do that. Not so. What they need is to understand how the Secretary of State works. What they need to know is how, when I'm starting a business, I need to have a well-drafted contract between myself and whomever I'm going to go ahead and service. Or if I'm providing a service as my next guest does, you know, or if I'm doing a DIY project and I'm making wonderful crafts, I need to be able to have a sales agreement, you know, or be able to kind of set up my website, or just to make those things to make my business become successful. We here at Pro Se Legal do that as well. And I don't just want to say that we draft your documents and file them for you, but we also establish a relationship. So my next guest, who I'm going to be bringing up shortly, is Lynnea Palmer. She has a very unique business, and she had come to us because she needed to have some contracts drafted to help her business. She came to us, we went ahead and drafted those contracts for her. She sent her on her way, and today she's here as a guest to go ahead and to promote the community service that she offers to everybody. So we at Pro Se Legal just don't want to be that go-between non-lawyer or a lawyer in like LegalZoom or any of those other entities. We truly want to invest in our clients to help them get from point A to point B. Why? Because when they're successful, we are successful. Why is that? Because the word of mouth starts going down the road. I bring a lot of different experience. As I said earlier, you know, I was the public relations director for the church. So my job was to get the church out of the 4 walls and into the community. Why? Because that's where the needs are. You know, everybody comes into the church because they have a need or they're seeking, you know, some sort of spiritual guidance. But what happens when you leave the church? How do we fill out that actual document? You know, who do we go to when we have a bankruptcy, you know, issue? You know, Pro Se Legal, who would you go to? Or, hey, can I file these documents on my own? Yeah, you probably could, but you need some assistance with that. So I just want to go ahead and extend the hand of fellowship to let you know not everybody needs an attorney for every legal situation. If somebody's working for a huge employer and there's an issue and the employer's cheating people on their hours and vacation time, and you come to us, we don't handle situations like that. We would then refer you off to Attorney Joe Richardson. So it's a way for us to create a community relationship to better serve our clients. So the next guest that I want to bring up is Lynnea Palmer. She is with A Place for Auntie. It is a very unique service that she provides for the community, and I'm extremely honored and blessed that she accepted our invitation, but I'm more so happy that we were able to help her get to this spot. Thank you.
Good morning, everyone. So just to piggyback a little bit on what Kim was talking about is I was actually praying for an attorney because I was opening up a business. So I was praying and asking God to help me find an attorney. And someone said, I don't think you need an attorney necessarily to open up a business, but it might be good to have a paralegal because I needed certain contracts for referrals. And so I was just praying, and I said, well, when it comes along, it comes along. And an attorney called me. I made some contacts with, and he was telling me that it's like $1,500 to $2,500 to get the process started. And I said, okay, well, I'll give you a call back. And then in the mail the same day, a flyer came through the mail, and it said on there, pro sale, paralegal services. And I go, well, see how God answered prayer, you know? So I went and I met with her, and she's just been a blessing to me, helped me work out my contracts, and helped me start my own business. And so I thank God, and I definitely appreciate ProSale, and I definitely promote ProSale wherever I go. So let's talk a little bit about Perfect for Auntie. So Perfect for Auntie is my organization, and what we are is a placement agency, referral source, that specializes in matching your loved ones to the perfect community for them. So let's describe your loved one. Their needs might be financial needs. Can they afford senior living? Can they afford assisted living or memory care? You never want to put someone in a community where they cannot afford, or they're struggling, or they have to borrow in order to afford just that community that they're in. The other thing is location. It's very, very important that you keep them close to their loved ones, to their families. If they're married, obviously she's going to want to be close to her home where her husband is or where his wife is. They also want to be in a familiar location to where they are. So if they're familiar with that city and they're going to be going out and doing transportation, or maybe they're doctors in the area, they're going to want to stay in that city because that's where their doctor's appointments and everything is set up. Their whole life is there. And so you definitely have to keep that in mind when we are placing people in senior living facilities. The other thing is their spiritual needs. What about their spiritual needs? If they don't allow me to practice Christianity, I can't have Bible study, why would I want to be a part of that community? If I can't be a part of Lent, why do I want to be a part of that community? What if I'm a Muslim and they don't allow me to practice that? You want to be able to take the lifestyle that you have at home and implement it in this new community that you're going to be moving to. What about nutritional needs? Can anyone tell me what's the number one complaint in senior living? The food. It's always the food. So if there are certain meal plans that are not being implemented there, only French fries and cheeseburgers every day, do they not make Italian food? Do they know how to make Mexican food? It's very, very important that you continue to live those lifestyles. So if they have a specific nutritional diet, then you're going to have to go by their nutritional diet. Obviously, low sodium, things like that. They might have high blood pressure, cholesterol issues. The physicians will set that up with you. But nevertheless, if they want a slice of cheesecake, they want a chocolate chip cookie, they usually have that at home. You don't want to put them in senior living and then they start taking all of that from them. That's not going to be any fun. So that's very important to you when you're looking for your loved one. You're going to be saying, my mom loves chocolate chip cookies, but a doctor says she can't have them all the time. My mother loves Italian food, but he doesn't suggest that she has a high sodium diet or something like that all the time. So we're looking at those types of things. We're asking those questions because it's very important to us. What about her social needs? My auntie loves, I have aunties, but for example, I'm just going to say for example, perfect for auntie. My auntie likes happy hour. So you're moving your loved one into the community. She or he enjoys happy hour. So if this community does not exercise happy hour, she might not want to be there. And it's not always about the alcohol. It's not about the drinks. A lot of times it's about the social interaction. They get an opportunity to meet someone new. They get an opportunity to engage and have conversations with people who are on their level. She's a retired teacher. She wants to meet retired teachers. He's a retired physician. He wants to talk to retired physicians. They're looking for someone who has the same thing in common with them. Let's be honest, seniors do not want to sit up and have a conversation all day with millennials. That's not going to work. You know, they're talking about YouTube, and grandfather sitting there like, what is YouTube? I don't even know what YouTube is. So we have to make sure at Perfect for Auntie, we're keeping those things in our mind. That is very important when we're looking for the perfect community for the senior. The other thing is long-term care. How many of you are familiar with the term long-term care? Okay, a very minimal amount of people are familiar with the term long-term care. So long-term care services, people assume that it's being only implemented in convalescent hospitals. You have to go to skilled nursing. But long-term care services are being implemented right now, probably in your home or someone that you know. Maybe your neighbor right now is probably, how many times you see her daughter taking her in and out? She's going back and forth to the store. Maybe they're transferring her in and out of the wheelchair. She has a walker. You see someone that looks like a caregiver that might be providing services to her. Children are doing their grocery shopping for her. Basically, a lot of services are being provided to her, maybe by her husband, maybe by his wife. They're no longer able to drive. Those are long-term care services that are being provided for them because the physician says they can no longer do it by themselves. Very important for us to make sure that when our seniors are transferred into these communities, these services that are being provided at home is going to be provided the same way once they become a part of the community. Otherwise, why would mother want to be there? It's just not going to work. The other thing that I really want to point out was, according to AARP, nearly 90% of seniors want to stay in their home for as long as possible, and 80% believe that their current residence is where they're always going to live. In contrast, the U.S. Department of Health and Human Services found that 70% of seniors 65 and over will need some form of long-term care in their lifetime for an average of maybe 3 years. So long-term care services can be implemented short-term or long-term. Let me describe a patient. Here's a client that I have worked with before, but I'm going to call her Lynnea Palmer, which is my name. So Lynnea Palmer's family came to me. She had paralysis on one side. Lynnea is resting in a skilled nursing right now. They're going to release her, but she does have to get temporary rehabilitation just to get her to be able to exercise and work on one side of her body as much as she possibly can. According to the physician, it looks like she will not be able to gain back 100% of the function. Maybe they're estimating 40% of the functioning on one side of her body. So the family comes to me and they say, my mother was an active adult, 74 years old. She lived her life. Her and my dad, when my dad died, she started dating again, getting out and socializing. One of the things that she really enjoyed was knitting. She loves to knit, she loves to socialize, she goes to church, and she wants to continue implementing those services, doing that, living that lifestyle when she becomes a part of this community. So it's very important that when we're transitioning people into communities, we're talking to the community and we're describing Lynnea Palmer to them. This is important to Lynnea Palmer. Can this be done for Lynnea Palmer once she becomes a part of your community? Remember something about senior living. Senior living is giving you back your life. They're not taking it from you. 90%, I'll say 100% of senior communities, the idea is to say, you're not able to do it, let us help you, not let us take from you. That's not what they want to do. They don't want to take your keys and put it in their pocket and say you can't drive. They don't even take your cigarettes. They allow you to walk outside and have a cigarette and smoke. They do implement happy hour. You can have a drink. So if you like that, you like to have a shot every night before you go to bed or a glass of red wine, you can have that there. It's about aging with dignity. And the idea for me as Perfect for Auntie is to say, I want to make sure that when she's a part of your community, it's with dignity. Give her back her life. Does that make sense? The other thing is that we want to make sure that when you're contacting and you're calling me and you're saying that you're describing the person to me, I always want everybody to know my services to you are free. To your loved ones, your family, your friends, to the community, my services are free. You do not have to pay for them, so you're not paying for my time. However, I am contracted with local facilities. And with those facilities that I'm contracted with, you can choose to transfer there or somewhere else. Because my focus is not where I'm contracted. My focus is to meet the need. If mom's need is financial, I'm not going to take her to a luxury community where it's too high expensive and I'm contracted there. I'm not going to focus. I'm going to focus on her need. And financial is one of them. We're going to start there. So it's very, very important that you understand that when you're talking about Auntie, or if you're calling or you need our services, you understand that we're not focused on where we're contracted. So if it's a brand new community, I was working with someone not too long ago in Northern California. So if it's a new community that I'm not associated with, I will make my way over there, get the information from that community, bring it back to you, set up an appointment, and we will tour together. We will learn and discover that community together because that one is important to mom. That one is important to dad. It's important to Auntie. So those are also very important things. And then lastly, I just wanted to finish with saying, I am not a mom, but I am an aunt. So as being an auntie, I have 3 nieces, and together we put together these folders with some information there. My website, my phone number, all my information is there. And when you're walking out, you can grab some of those folders that have all of our information there. If you have any questions, please call me, email me, perfectforauntie.com, look us up online, and find out what we're about. The other thing that we do is we try to connect you with resources that we don't provide. I don't provide paralegal information, but I do have them on my website as a resource in case you need that information. So Alzheimer's Association, when it comes to dementia and Alzheimer's, I can tell you about dementia and Alzheimer's, but they can go into more in depth. So I can tell you about the communities that would be best for that particular behavior, that aggressive behavior, mild behavior, who can handle this, who can handle that. But I stay away from the detailed information that you really, really need to know about your loved one. The other thing that makes Perfect for Auntie very unique is that in order to work in these large RCFE facilities, you have to have your state administrator license. I have my state administrator license. And when I'm placing your loved ones, I'm thinking like the administrator. So what's important to the state is important to me because my license is on the line. So I'm not going to refer you to any place that has red flags. If it does have a red flag, it might not be something I'm aware of, but I'm always investigating and doing research in the community to see where they're at right now. I also urge my clients to go and check out the community, look them up online, find out where they rate. It's important to know these types of things because at the end of the day, we're talking about long-term care. This is the rest of your loved one's life. And it's important that they live out the rest of their life with dignity. Does that make sense? So keep in mind that in Perfect for Auntie, we believe in a change for the best. The other thing that we also believe that it takes a village. It takes a village to nurture a senior. If anybody have any questions for me, you can go ahead and ask online, or you can take the opportunity to ask me right now. I do have one question that I am going to answer, and that is, on an average base for senior living, the cost of a basic senior living will run you anywhere from $5,000 and above. Right now, I'm currently contracted with all Brookdale Senior Living Communities, and I just did a placement in Walnut, and we did a placement with her. They're running a special. They're taking $1,000 off for 90 days. But let's say that she didn't have that special. Her total cost was about $5,000. And that was just for a one-bedroom studio, basic size, rehabilitation room, so it's fully, everything was new. They gave her a fully furnished bedroom, television and all, which was a definite bonus because it was kind of something that they needed on the fly. But they accepted her fully furnished and all accommodations to her. So always remember, don't shy away from the price. Don't be scared, because you never know what they're going to give you on top of those prices. Because at the end of the day, they want to make sure that your loved one's needs are met. It's about the need. It's not about the price. They're not trying to get rich. Obviously, you have your luxury adult living communities, active adult senior communities, your CCRCs. These are communities that the seniors have invested in, which are much different. If you guys want to call me and ask me questions about that, I can give you more feedback and more information. The last thing I like to do is encourage everybody, I don't care how old you are, you could be 25 years old, it doesn't matter. I encourage you to go by your local senior community and shop it as if you were shopping a brand new home from Toll Brothers. If KB was building a brand new housing market, you guys would go by there. Esperanza in Ontario is building a brand new 55-plus senior organization, beautiful community. I urge you, go and shop a senior community, and you will find out it's nothing like I thought it was going to be. And when you need that community, you might just need a temporary 2-week respite. It's the way to go, as opposed to staying at home and paying someone over $5,000 to implement maybe 8 hours of care. Any questions? If not, I'll go ahead and take my seat. Thank you.
This is good information, for sure, and that's what we're really trying to do. And I will say very quickly, Lynnea rolled deep today. I think everybody Lynnea is related to is here. They are the crowd. So thank you for coming through, because we didn't know what we was going to do with them donuts if we didn't run out of them. So thank you. I sure do appreciate that. You know, it's a village. We all work together, you know. And so now, is this Auntie? That's Auntie. Okay, hey, Auntie. A place for Auntie. A place for Auntie. All right. That's good. Fantastic. No, but this is excellent information, you know, when you have just something that you think about. You know, you've got older family members. Maybe they're doing fine right now, but you do want to scout those things out and understand that. And so I appreciate that, and I see the connection between you two, Kimberly. Did you have a question or comment?
Well, no, I had a statement.
Okay.
I was hoping Lynnea would actually say it, but most of those senior living, when the loved one is now residing, they want power of attorneys on file.
Right, sure. Right.
So that's where the relationship still continues.
That's right. And remember, powers of attorney, a lot of folks come and ask you about having a power of attorney about somebody that's passed. And that doesn't help. Powers of attorney is for when they're alive, okay? And if you didn't know that, make sure you get that squared away, okay? So, but that's really important. So now, it's all fun, but here's the part. I love it when these two speak together, one after the other, because this is the carrot and the stick related to housing. Everybody needs housing. Not everybody has housing. Sometimes it's difficult. Sometimes it's difficult to get, difficult to keep. There's a lot of things going on. But I'm going to have Linda Jackson come up next. And Linda Jackson is at the Inland Empire Resource Center. And once we got together, we've got some mutual friends through church and everything else. But what she does is so incredibly useful. It's important to understand these resources that exist and that are out here related to housing, related to folks that are trying to preclude foreclosures and those types of things. And then after Linda comes and talks about the carrot, then we're going to have Brad Baldwin come up who's a landlord-tenant lawyer and talk about what's happening with the moratorium and if it still exists and what that looks like. So that's going to be really important. This is some good information. Linda, we're always glad that you're here. Thanks for coming. Come on, Linda.
Praise God. Is your pastor in the house? Okay. Stepped out. What I want to say personally to thank him for allowing me to be here. Thank you for your senior living care. That is something so important to me. My husband, before he passed 7 years ago, I had to put him in a skilled nursing facility. So I understand everything, lived it, understand it. And then I want to say thank you to my girl, Kim, because I call on Kim all the time, and Kim has also helped me with my living trust about my own property, so that's great. Then I want to say thanks to Brad because I also deal with tenants, and I needed a legal advice on taking over a project that has over 5,000 tenants. So, my name is Linda Jackson. I also run my own business, and it's a nonprofit, and I've been doing it for 10 plus years. But I have to say, my steps have been ordered by God to do this work because we're all here to serve, so I'm a servant. The biggest thing that I found out in this time, are all of you from the church here or just not? Okay. So what I want to say to you, I always want to know who my audience is. Does that make sense? It's very important that I know who I'm talking to because I want to know what you need. And this might not be for you, but it could be for someone you know. So back in 2008, we had a mortgage crisis. Everybody needed help, right? And they really kind of looked upon us, African Americans and Hispanics, that you shouldn't have got into that subprime loan, right? But we did all of these loan modifications. Now let's forward to where we are right now. Today, it's a life and death crisis. So we've never seen this before. So what I'm about to share with you, it's hope, it's help like never before. So how many of you own a house? Raise your hand. Okay. So the rest of you are living at home with a parent, or you living in an apartment, right? How many of you would like to get out of that apartment? Praise God. Praise God. Okay, so I have the right audience in the house. Make sense? Now, I said my steps were ordered through God. Most of my clients come from the church because that's where I started in 2008. So if you were struggling to make your payments on your mortgage because of the mortgage crisis, and then some of you got furloughed on your job, which meant some of you couldn't tithe to the church like you used to, right? So that meant your pastors were in trouble too. So the first thing I did is I went to the church, went to the pastors, helped the pastors. The pastors allowed me to come in to help his sheep. So that's how that went. But now, today, people are fearful, okay? They're fearful because they might not have been able to pay their rent. Thank you. Hello, can you hear me? So after that happened, are you guys still following me now? Did that affect anybody in the room? Okay, so it didn't affect, but did you know people that it did affect? Okay. So after that happened, they had to create programs to help us get through the pandemic, right? So right now, my goal is to raise the awareness of where that help is, to get you to that help, and to get you out of any situation that you or your family has. So today I have been funded not just to help us in the room, but the entire state of California. I'm also funded under HUD. So I have the state and I have the federal. All of our services are free. So I want you to spread the word because there's somebody that you know. So there is a fund, if you want to tell somebody in your church, it's a fund that's just come out because of the pandemic. It's called the Homeowners Assistance Fund. So I want you to listen to this. The state of California has gotten $1 billion to assist homeowners who are struggling because of COVID-19. The assistance that they have gotten, because I'm saying this is a life or death situation, they can get up to $80,000 to assist them with their mortgage. Now, you're going to need me in order to do that, though. You're going to need a certified HUD counselor, and that's what we all are. The mortgage, they also have what's called the Mortgage Relief Fund that you can apply for. Here's a couple of things, and it may not make sense, but you're going to tell somebody to call me. If you have a mortgage now and you were under COVID-19, you lost your job, your kids couldn't go to school, the schools were closed down, you couldn't go to work, they will take your mortgage payment, and what they'll do is they will do what is called a partial claim. I'm not going to go through a lot of detail, but they will reduce the principal on your mortgage. So if they take a portion of the principal, do you guys know what I mean when I say principal? Okay. They'll take a portion of that and set it aside, because what they're trying to do is to get that mortgage payment, so you know, to where you can afford it. Because once you come to me, I'm going to do a budget, because I'm going to tell you how much house you can afford now. I do that when we also do first-time home buyer classes. Also, you get down payment assistance with that, but I'll tell you about that real quick. But what they do is they take that aside. So now they're trying to see if that's good enough for you. If that doesn't work, then they look at your interest rate to see where your interest rate is. Everybody's heard about the interest rate. It's at an all-time low. Then they'll lower your interest rate to make that payment affordable. These things have never been done before. Our goal is to make sure that nobody is foreclosed on. That is the goal that they have now, like I have never seen it before. Now, some of you who are renters, have you heard of the Renters Assistance Program? Has anybody heard about that? You guys have. Have you guys needed any rental help? Okay, do you know people who do? Probably somebody out there. But the rental assistance will also pay your rent up for 12 months. So you could get that today. Therefore, with the landlord, it pays it to the landlord. So now, coming forward, after that's done, they will also help you get on your feet, you tell somebody this, to pay your rent going forward for another 12 months, just to get you back on your feet. There's also utility assistance. If you can't pay your light bill, gas bill, there's funds out there for you as well. So what does the word say? Our people perish because they don't have this information. They don't have this knowledge. So I'm giving you knowledge that you will have if you know a friend or somebody who, how many people call you on the phone talking about what they're going through and they need prayer? So now you know there is a source. I'm a resource center. It may not be the source, but I can always get you to the source. So as we go further through this, everything to get any help with rent, with utilities, has to be COVID related. COVID related doesn't mean you have COVID or you got COVID. It affects you in some type of way. So that's very important for you to know. One of the last things I want to say to you, and it came in my notes as well, anybody after January 1st, 2022, nothing is going to happen that I believe, but Brad is going to tell me that's not going to happen. I believe that no one is going to get, well, I won't say no one, but the majority will not be evicted nor foreclosed up until January 2022. So we're talking about next year. Because of the fact this is how it's been in the past, we're going into the holidays right now. Nothing is wedged in stone. I'm in church, so I can tell you what I'm believing God to do. Okay, let me first make that clear. They don't put you out during the holidays, okay? Especially right now because of a pandemic. So evictions are going to be harder right now because we're going into the holidays, and Brad will talk about that when he comes up. The next thing is people who were already had a sale date on their property, meaning that they were going to sell before the pandemic. But when the pandemic came, there was called a moratorium on foreclosure evictions, rental evictions. You couldn't evict anyone, provided, and Brad will say there had to be a declaration that you had filed, stating that it was COVID related. What I believe, and this is the urgency to the people that I'm talking to on the network, the urgency is you need to get information before January, because after January, that's when they have the right to go ahead and start the sale dates all over for the foreclosed mortgages, okay? So if you know anybody in that category, you want to say, you better call that lady so she can tell you what can be done to help you not lose your house. We're afraid to go get the information, you guys. We're afraid to call the lender because we don't know what they're going to do. We're afraid because we can't figure it out. And all of that is the trick of the enemy. There is help for everyone who needs it. We're afraid that at night we can't sleep. We honestly can't sleep because we're worried. I want to say to the internet audience is that eviction or foreclosure, it tears up the family. You go through traumatic experience with your kids, and you and your wife, your husband, you're fighting. You're fighting all the time. There is no peace in that house. No peace. So, with that being said, I want to leave you with this. What would it take to get you, somebody you know? I get calls all the time. Pray for me. I'm going through this. I'm going through that. We actually handle credit restoration. Everybody needs credit. We also handle money management classes. Go online and take our classes in your pajamas. If you want to get out of that apartment, we also do first-time home buyer classes. They're online. You can take it at any time. Once you finish with that first-time home buyer class, you will get a certificate, HUD certificate, that will allow you to get the down payment to buy your brand new house. So think about this. This is getting ready to come out. In 1960, it was legal to discriminate blacks and Hispanics to buy a house. That was 1960. It was legal. Today, it's illegal. However, today, it's worse than it was in 1960. So, coming from the White House, we're saying there's going to be a new initiative, and that new initiative is going to be for black home ownership. You're going to hear that come out. It's not even out yet, so you guys are getting it firsthand. And what I would love to see as I go through the churches is to empower you with this knowledge that there is hope for each and every one of us who would like to be in a home. And I really would love for you to reach out, get my information, because there's something in there for everyone. Homelessness, we do that too. So renters, we do that too. So I just want to tell you, thank you, church. Thank you for being here. I pray that I will come back again to give you more updates and more information. And I have my information on the table. If you have any questions, you can ask me now, or you can ask me when I'm with Brad or whatever. Any questions? You have a question? Okay, may I help you? Your question?
I talk loud.
It's for the live stream.
Okay, I'm not trying to tell my business, but I am on Section 8, and I live in an apartment, and I want my own home.
Did you know that your down payment will be your voucher from Section 8? Did you know that?
No, but come on, Jesus.
All right. So,
Yes, I want my own. I can hear you. Yes.
So you're on Section 8.
Yes.
Your voucher, your down payment assistance is going to come from Section 8. So your case manager is going to tell you, you need to work with a HUD counselor. That's me. I need to prepare you to get you ready to buy that house. So that means that when you call me, I got to do a budget. I got to find out where you are, where you fall, how you fall in place. Then I'm going to talk to your case manager, and we're going to talk about that. Those properties may not be out just right now, but don't wait till they come. My thing is, we wait, guys, until it's here. Why don't we get prepared now for when it comes? Some of you who are in apartments right now, you want to get in a house, but once I pull your credit report and I see what work I have to do, because it's all geared around your FICO score, you got me? And I also work with credit, so I know, I don't know if I should say this, how to play the game. And where to get your FICO score, where it needs to be in order for you to get a loan approved.
Okay.
Your loan is different because when you talk to your case manager, they want you in a home.
Okay.
They want you out.
Okay.
Okay?
Yes.
So they're going to be helpful to you to make that happen.
Okay.
You're going to pray about where you're going to move, and you're
Yes.
going to pray how God is going to open the doors.
Yes.
God is in control, not
Yes.
me, not Section 8,
That's
not the
right.
bank or nobody else.
Yes.
Because that's where our help comes from.
Yes.
So that's how you're going to get into that house. I'm looking
Thank
at you
you.
straight in your eyes. I'm looking at you right now. I don't know who you are. I don't know what your situation is.
That's my big brother.
You want to get in the house.
Yes, he.
That's
look
all
at
I
God.
know. I'm just looking at your heart.
Ah.
You want to get in the house. How bad do you want it?
Here, baby.
I'm good. I mean, I can't talk anymore.
Oh, he just. Oh, he.
How bad do you want it?
Here she go.
Well, here's the deal.
Look at Jesus.
If you work with me for 1 year, look, brother, if you don't call me, shame on you. That's all I can say. That's all I can say.
Come on.
That's all I can say. You need to call me so we can get you ready to get into that house.
Amen.
Okay? We're going to trust God on that.
Yes.
And believe God. I heard my timer go off. That was my Siri telling my 20 minutes is up. God bless you guys.
Thank you so much, Linda. She's saying what we get from it, what you ought to get from it is, faith people, but faith without works is dead, right? And a lot of
That's
people
right.
think that because we have a hot market, that you shouldn't be preparing for this situation, whether it's credit repair, finding out what it is that you need to know, because you're concerned about how difficult it may be. But, you have to, if you're non-spiritual, you'll say that luck is when preparation meets opportunity. I will say that faith without works is dead. So let's do our part so that it can all come together and the things that need to happen can. There's a lot of free money out there to help people get on their feet that aren't on their feet, to help them keep. You could be a year behind and end up a year ahead, okay, if it's COVID related. And so make sure that, you check with Linda, make sure that folks know. So next up, my closer today is my man, Brad Baldwin, and he is an in-the-box landlord-tenant lawyer. He understands it, backwards and forwards. He works with the law offices of James Blucker. He is in, I don't see a hierarchy there. He is in the trenches trying the cases. As a matter of fact, I tried a UD, and one of the things that he told me afterward was that this particular judge is not a good one to try one in front of, and I found that out the hard way. So it's important to understand somebody that not only understands the law, connect with somebody not only that understands the law, but also understands the judges, how things are getting to trial, how counties vary. He's going to have different information based on county as well. And one of the things that we want to do, I want to say it out loud to my production folks, let's make sure with this online on-demand product that during each person's speech that their contact information is there somewhere, okay? Maybe it's toward the end of the speech or however we do that, whatever makes sense visually, okay? So let's bring Brad Baldwin up. Brad, come on, man. Thank you.
I'll hold it. Yeah, sounds good. Good afternoon, everyone. Thank you for having me. Thank you, Joe, for bringing me in on. I was here earlier this year to my experience, the community greatly desires. Test. Okay. The eviction moratorium, yeah, that is still ongoing to some extent. It's sort of complex. I do my best to break it down to understand as easily as possible. First, I would like to go into a cursory background as to what the California legislature had started over 1 year ago once they created these COVID laws, and we'll follow that into what the current status quo is for all the surrounding counties by us, because the laws may apply differently if you're in Los Angeles County versus here in San Bernardino County, Orange County, Riverside County, and such. Going back to August, September of 2020, that was when the first set of COVID laws as it related to evictions first started. Essentially, if a tenant was behind on rent, so pre-COVID, we'll jump back even a little further, a tenant would be given a 3-day notice to pay rent or quit, and they would have 3 court days, so weekends never counted, court holidays never counted, to come up with the rent or vacate the premise. Then starting in September of 2020, that law changed to a 15-day notice, which also didn't include weekends or court holidays, and it essentially included that a tenant would need to sign a financial declaration under penalty of perjury that they were impacted by COVID and that they could not pay the rent. And as long as they timely returned that declaration within the 15-day period, which usually factored out to 3 weeks, 3.5 weeks or so, depending on what month you were in, how many court holidays there were and such, it gave a lot of time for a tenant to sign that declaration and ensure that the landlord received it. If the landlord did not receive anything back from a tenant, that would allow the landlord to file for the eviction lawsuit for non-payment of rent, but a tenant could still have an opportunity to still file that declaration in open court, to have a separate court hearing. That way a judge could decide whether a tenant had excusable neglect, meaning they had a really good reason why they didn't timely return that declaration. That was the law for non-payment of rent up until September 2021, and it's a little bit modified now going into October 2021, at least through March of 2022. They have reverted back to a 3-day notice to pay rent or quit, but there's a lot of contingencies attached. This isn't like pre-COVID, where upon expiration of that 3-day notice now, you could just quickly file for the eviction. It doesn't work that way. In fact, if any landlord wants to pursue any eviction for non-payment of rent right now, they have to apply for rent relief. That is mandated. That's because there are billions of dollars available from the 2 federal stimulus packages that have just been sitting there. I haven't looked at the latest statistics as to how much has been dispersed, but I could tell you from my own personal experience, I've assisted on these applications on both the landlord side and the tenant side. They're very arduous. They require a lot of information, and it could be very taxing to fill out this information. The one that I personally participated in, it took me 3 weeks to fully fill out on behalf of a tenant, to where they wanted all of their driver's license, utility bill information. The entity was requesting unemployment stubs going back to last year, if that applied. They also wanted to see their checking account information, savings account information. The rent relief entity wanted a tenant to prove to them that they met that threshold, meaning a tenant has to be making 80% or under. It's a threshold formula that's set up by the state or by the county, and a tenant essentially has to prove to the entity that they qualify. And in the beginning, when these applications first opened in March of 2021, they were taking a long time to do. I believe they've gotten a little bit better since then, but if a tenant is currently behind on rent in October going through March of 2022, that landlord has to apply for rent relief. They can't file the eviction unless there are 2 factors. One is that the rent relief entity contacts the landlord after the landlord has submitted an application and says the tenant has not applied. It's been 3 weeks. We have no information that the tenant has actually participated in this. Upon confirmation from the rent relief entity, past that 21-day window, that would allow the landlord to then file for the eviction lawsuit. Another caveat would be if the landlord has applied, but there's no pending activity ongoing with the application, or maybe the tenant was denied. I don't believe I've seen any cases where a tenant is that quickly denied. I don't know where they came up with the 3 weeks. You could thank our legislators for that time frame. If it were up to me, I think it should be 4 to 5 weeks, just based upon government red tape and the amount of time it takes to fully process these applications, and the workers from the state that are assigned to it and going through it. They have a huge caseload right now. Another factor to consider is if the tenant had applied but there is no activity, because the rent relief entity has taken some time, the landlord may still be able to file, but there's still relief for the tenant come court, meaning that lawsuit is filed, the landlord will then attempt to serve that tenant the lawsuit. Usually there are some weeks in and far between, and this will depend on the county of where the eviction proceedings are, because not every county is at full steam with their court clerk's office, meaning some counties you can't walk into the courthouse to file these cases. They have to either be submitted through the mail, maybe a Dropbox, or through electronic filing. Some counties act a lot quicker than others. For example, there are some courthouses in Riverside County that take anywhere from 6 to 8 weeks to get a lawsuit back. And if the landlord had filed for that eviction for non-payment of rent because there was no clarity whether the tenant was denied or that they didn't qualify, then perhaps, throughout the midst of that 6 to 8 week period while the landlord's waiting for the lawsuit to be processed, perhaps the tenant does qualify at that point. And if so, there are new court documents available on the court's website that will allow a tenant to file a motion to seek relief from eviction, meaning, hey court, I'm bringing to your attention that the landlord is likely to be reimbursed. I've been approved for the application. I want my day in court. And pursuant to these current COVID laws, Your Honor, you have the authority to dismiss the lawsuit contingent that the landlord will be made whole. So there are a lot of checks and balances that will be ongoing from this month to March of 2022. Hard to say what will happen around that date. I imagine if I have to look back over the last year with what the legislator has done, I would not be surprised if there's either some type of extension with the current status quo, or perhaps a new set of laws gets drafted by our legislator, probably sometime in January when they're back in session full-time again, and then introduce legislation and debate it. As I stated earlier, there's a lot of rent relief available. There is a state website called housingiskey.com, and for the most part, most counties and cities are utilizing that website, that entity, to disperse all the rent relief. However, when the California legislature set up these COVID laws, they also gave entitlement districts, meaning cities, counties that have more than 200,000 population, the option to set up their own rent relief. So Riverside County, for example, they do their own. They're not adhering to the Housing is Key state portal for rent relief. They use United Way. In the beginning, when these applications first opened, my experience was through United Way, and I actually had nothing but positive things to say about United Way in terms of how they were processing these applications, the manpower that they had behind it, and a lot of funding. Separately speaking, there right now are 2 categories for evictions. That's what I call it. It's something I made up because there are so many ways that an eviction case can be prosecuted. For the most part, during COVID right now, I just say, well, there's 2 categories. Category 1 is an at-fault reason, meaning, hey, tenant, you did something wrong, you breached the lease somehow, and I want you out. Category 2 is, tenant, you did not do anything wrong. However, I want possession of the property back for a valid legal reason during COVID. These 2 categories are based off the state law. However, there may be some variations depending on locality, where you are. Los Angeles County, for example, is vastly different than the state law. So right now I'm just talking about the state law, but if later on you want to talk to me about Los Angeles County, I'd be more than happy to. I'm very well versed in what's going on there as well. as I said, category 1 is tenant, you did something wrong, I want you out. That could have been the non-payment of rent, which is the most common issue that's talked about right now when we talk about the eviction moratorium. There's some other at-fault issues that aren't always talked about, such as failure to provide access to the landlord when they've given proper legal notice, unauthorized occupants that are not allowed on the lease, same with pets. These are what are called at-fault reasons. Was there a material breach involved, perhaps not related to money? If so, a landlord would be required to serve a 3-day notice to perform or quit. As long as it doesn't relate to money, that would be a 3-day, and the tenant would have 3 court days to comply with whatever they're being put on notice for. Separately, thereafter, after that curable breach period is over, if the landlord has to then confirm that this breach is still ongoing. If so, they can't just immediately file for the eviction lawsuit. They have to serve what's called a final 3-day notice to quit, meaning this is now a material, non-curable breach, being that they first put you on notice of whatever that curable breach was. Category 2, the no-fault eviction, that is still ongoing a lot in San Bernardino County, Riverside County, in Orange County, not so much LA County except for owner-occupied move-in, but essentially that means that during COVID, you needed at least a valid legal reason to evict. You couldn't just give a 30 or 60-day notice to a tenant to vacate just because. A few years ago, you could. In 2019, that changed for multifamily properties, so apartments, duplexes, triplexes, and such, to where the California state legislator said, if you are attempt to evict for a category 2, no fault reason, you needed a valid legal reason to evict, meaning was the owner or someone in their immediate family going to be moving into that unit? Was it the landlord's intention to get out of the game altogether, to withdraw the property from the rental market? Did they want to do substantial renovations that would last longer than 30 days, but couldn't be just these rinky-dinky repairs, as I call them, saying we're just going to redo the bathroom countertop? No, these renovations would have to last longer than 30 days, such as a major renovation. Maybe you're redoing the whole kitchen, a few bedrooms, flooring. Cities have stepped up since then because that's been a major loophole that's been utilized. So now they're requiring landlords to go an extra mile and actually pull permits with the cities and submit plans in some of that. So that kind of closes that loophole a little bit. And then the last reason would be is if the landlord has entered into a contract to sell the property and the buyer intends to utilize that property as their primary residence. During COVID, those were the main 4 valid legal reasons to terminate a tenancy where a tenant was not at fault. I went to a landlord-tenant section with other attorneys a few weeks ago, and this is where we were debating what's the law now, being that all these protections were supposed to only last through September 30th. What is the law now as it moves forward for October and onwards? And it really depends on what is the landlord trying to do? What are they trying to evict for? And that's where it really varies from county to county because the rules may be different. When the California legislature set up these laws, they allowed these local cities to draft even stricter criteria, like LA County has, for example. In LA County, you can't essentially do any category 2 no-fault eviction except for owner-occupied move-in. However, there's so many boxes that a landlord has to check to properly do that. One, it calls for mandatory relocation in LA County, and that will depend on the household size. It'll depend on the tenants inside. Do any of them have any underlying health conditions? LA County says you can't evict someone who has underlying health conditions when you're moving in and you don't have any underlying health conditions. Both parties would have to be similarly situated, exposed to the same conditions, essentially, if the owner wanted to move back in. I handled a case recently on behalf of a landlord that was adamant about moving back into their property in LA County. I properly advised them of everything they had to do it, and we were able to come to a settlement agreement with the tenants where the the tenants, they were paid over $16,000 because that was what was required by the county. They had their own formula set up. So that worked out. But I can't say that will always be the case because not everyone is prepared to move. Not everyone is prepared to be, uprooted from where they've been living for however long, just because these new laws allow the ability to. A lot of this is based upon, is there consent from both sides to move forward with it. Another common question I get is, what about all that past due rent that was owed at the beginning of COVID, March 2020, through September of 2021? Because when you would do that 15-day notice for that Category 1 at-fault reason, even if you were able to get an eviction judgment for possession, the courts were not awarding a monetary damage against the tenant, and they were not allowed to even be sealed as well. That's where, starting in November 1st, a landlord can now file a small actions claim, whereas small claims is usually capped at $10,000. For this purpose, though, the legislator has lifted that cap to unlimited, meaning if it's more than $10,000, that's okay. We're trying to advocate for attorney representation in these actions because sometimes that amount in controversy, the amount sought, may be more than $25,000. And in court, that is what is treated as an unlimited civil claim, whereas attorneys can represent in those unlimited civil claims. So that still remains to be seen. I'm hoping that I'll be able to assist either a landlord or a tenant. FYI, I represent both sides. I've represented both sides for both commercial and residential. I have really good success stories for tenants during COVID where I look at what the landlord attempted to do. They didn't do it correctly, and I was able to win that way based off of that technicality. But that's how you win these cases for the most part, because they're new laws, they're so complex, and it's very rare that anyone understands them. You have to really know what you're looking at, and you assess that on a case-by-case basis. As I said, November 1st, also, for any eviction from now, October 2021 through March 2022, the judges will likely start awarding these monetary damages. That's why it's very important that if there's any past due rent at play, apply for rent relief. The landlord's required to apply for it. And that will just also depend on, well, how much is it going back for? Linda was correct in the sense that housing is key. For example, they usually pay for up to 12 months. So if a tenant was behind, going back 1 year ago, the entity is likely to clear that. I had a case recently here in Ontario where that was the situation, and the entity also paid for 3 future months of rent as well. I believe Riverside County was doing that as well through United Way, at least through my personal experience at least a few months ago. But I wouldn't be surprised if this changes throughout the current times here. If there's anything that I've learned with these complicated, complex COVID laws is they could change very quickly. They've changed 4 times. I've counted at least 4 times since the beginning of the pandemic. And that's where initially lawsuits weren't even being filed at all. Courts were closed. The Judicial Council, that is the third-party entity of the courts, they said no evictions could take place from April 2020 through the end of August 2020. No one could file one. There was a lot of lawsuits filed by landlord law firms to try to undo that, but none of them were successful. It remains to be seen what will happen come March 2022. But if I have to be a betting man, I would be betting that our California state legislator will be having more debate sometime in early to late January to be properly prepared for what's to come. Other than that, that is a nutshell on evictions in general. LA County is doing its own thing. As I said, the city of LA, most definitely, I believe within the last week, the city council there decided to continue to extend their own local moratorium for non-payment of rent until they declare the local emergency to be over. And whenever they do that, that would still be ongoing for at least 1 year. And right now in LA County, unincorporated or some other incorporated areas, at least for commercial, that moratorium is in existence at least through January 2022. But the non-payment of rent, that category 1 at fault, if a tenant's behind on rent right now in LA County for the most part, not the city of LA, they are following that state law. Meaning that landlord's trying to get a tenant for non-payment of rent, they have to apply for the rent relief. And they're going to need clarity from that entity as to, well, what's the status of the tenant's application? Were they denied, or is there no activity that allows me to move forward? But there are these loopholes that exist for a tenant, whereas if they didn't qualify right away, there is still time. They could still ask a judge to intervene and stop the eviction. They have the authority to do that. I would believe that any judge should do that. LA County most likely. Riverside County, depends which courthouse you're going to. If it's somewhere in Riverside, Corona, you go to that Corona court. I foresee that judge doing it. He's a very fair judge. If you go to the Moreno Valley court, and Joe knows this, if you're a tenant, you would likely non-stip to that judge, meaning that you don't consent to that judge to hear the case, and you want it transferred to a different judge because that judge, some people say that he's not as fair. I have no opinion over that. I've done both matters on either side before him. I believe him to be fair, but everything's so far in between. San Bernardino County, recently, they've had a lot of new eviction judges appointed within the last month or so. I met them recently at this landlord-tenant section. They came from the district attorney's office. They were research attorneys. So they weren't attorneys that had a lot of practice in this area. So they themselves are doing their best to fully familiarize themselves with these complex COVID laws and still be fair and balanced. And so far they have been. They've been doing a wonderful job procedure-wise. If there's a defect in the case, they will dismiss it. And that should just be, the common ground, is if there's any defect in any case, that should subject it to dismissal. Trying to think as well. Orange County, there's a lot going on in Orange County right now with judges, whereas judges are being routinely reassigned. My personal experience the last few months, I haven't had the same judge for an eviction case in Orange County like I have here in San Bernardino County at Fontana. But that's just where the supervising judge is likely dictating those judges' assignments. And there was one retired judge in Orange County who, I won't say his name, but he had told me that he was sick of doing these. He was tired of doing these eviction proceedings because of how complex the laws are. And he wanted out. He wanted to be reassigned. So he got his wish. Good for him. We'll see what happens as it gets closer to March 2022. Rent relief is available until it runs out. That is the important factor here. I would say that's the most common factor that I'm seeing for evictions right now, stem from the non-payment of rent. And I've been on both sides of that, to where I've seen tenants just give up, have no hope whatsoever, but not be fully aware that there are resources available. There are options available. Especially if you don't want this to potentially follow you for 10 years plus, potentially ruining credit, even though the laws say that it's not supposed to. That's why I'm here, to let everyone know that there are resources available. There is rent relief available until it runs out. I believe it was $5 to $7 billion that the state of California was able to get from those stimulus packages. And don't quote me on this, but I believe that only like $1 to $2 billion of it has been used. So not nearly enough. There are individuals hurting out there financially. Help is available. Please seek out those resources. Find out if it's housing is key, or some other entities such as United Way, United Lift. Joe did tell me that there was a question sent beforehand, and if I recall it correctly, that question focused on a landlord who is either attempting to sell their property or maybe it has sold, and there are tenants inside who refuse to vacate, something along those lines. And to answer that question, one, it'll depend on where this property is located. If the property is located in LA County, a lot further research would need to be done to see if the September 28th resolution from the Board of Supervisors in LA County would prevent the landlord from issuing that Category 2 notice, so that no-fault notice. Could be a 30-day, could be a 60-day, just depending on if that property's in escrow. But if the property is here nearby, if it's in San Bernardino County, Riverside County, or Orange County, that landlord could give generally that termination notice, likely a 60-day if they've been there longer than 1 year, 30-day notice if they've been there less than 1 year. But they may have to waive rent as well. And that's based upon that 2019 law that traditionally only applied to multifamily, that's been now codified for most no-fault terminations was, and I'm always seeing the nonprofit tenant law firms at court too. So I know what they look out for. They're looking for defects on notices. They're doing their job, and they're very competent at it. Whereas it's their position that something had to be offered, you know, whether it was 1 month of relocation assistance or a waiver of 1 month's rent. That's what these COVID laws say for the most part when you're trying to do that Category 2 eviction for a no-fault reason. It will depend on, is this a single-family home? Is it multifamily? If it's multifamily, that's a whole different situation. The legislator never intended to kick people out of multifamily housing that way for a no-fault reason, unless there was severe habitability issues or, like I said, that substantial renovation where they're not just singling out one unit, but redoing all the units. So to fully answer that question, I would need more information about where is this property located and if it's subject to any other local restrictions within that city.
Let me ask additional question.
Sure.
I've defended a couple UDs over the years, and I was always moved by how quickly things have to happen in the UD world, right? Back in the day, you had to answer your complaint within 5 days. Has COVID changed that at all? Or, once somebody appropriately files, right? We're talking about how they got to really jump through some hoops before they get to that point, before it can really go forward. How much time do they have to respond? Changed at all?
Yeah, so this will depend on how was the tenant served the lawsuit. Another thing to look out for is who is doing the serving. I will tell you that it's very common that a landlord will hire a registered process server. So a registered process server is someone who's licensed and bonded by the state of California. They went through a life scan background check. They have no outstanding felonies from what I recall as per the requirements, but California law says that when a registered process server does something, that there's a valid legal presumption to the effect of that service. So if a process server says that they personally served you, that burden is on the tenant to then, file a motion to quash or bring it to the court's attention that they weren't served correctly. And you'd have to do that before actually properly filing a response, subjecting yourself to the court's jurisdiction. Most tenants don't know that, though. Most tenants, once they get a lawsuit on their doorstep, they're not thinking about those, procedural devices such as, well, okay, I got the paperwork, I must have been validly served. This is where if a tenant is served that lawsuit, they should be checking with the court when that, if any proofs of service have been filed. My guess, they probably won't file a proof of service until they're trying to seek a default, which always be under the assumption that it's personal service. So 5 court days. That law changed in 2017, I believe, whereas it used to include weekends, but now when you're served a 3-day notice, so if you're served a an eviction termination notice prior to a lawsuit, whether it was a 15-day or a 3-day. Weekends no longer count as days, court holidays don't count as days. But always assume that you were personally served, meaning once you get that lawsuit, run down to the court or start figuring out how you want to respond to this lawsuit. You know, are you going to generally deny all the allegations, meaning, all right, the landlord's just going to request a trial date at that point when you have an answer on file. The answer is the formal response where you deny everything, and then the landlord has to file a document called a UD-150 to request a set of trial. But there's other options available too, and this is not commonly talked about as well. If you didn't, you know, if you felt that paperwork was just dropped on your door, then perhaps you should explore filing that motion to quash. That is a custom pleading paper motion. It is not one of those fill-in-the-blank forms that you can find online. You would have to do a lot of research or possibly hire counsel or go to Inland County, legal aid, legal services, or private counsel, have your consultation, and figure out if that would be wise to do. Similar as well, there are other possible motions that a tenant could file with, once they review the lawsuit, maybe the landlord didn't prepare it correctly. You know, I had a case where I was representing a tenant where the landlord attorney was trying to sue for all this past due rent and put everything on one notice, when in that situation, it should have been bifurcated on 2 different notices, because that's what the law said. So I filed my dispositive motion. I filed a motion to dismiss based upon that the lawsuit wasn't fully in conformity with these COVID laws, and the judge ruled for me. Side note, filed a motion for attorney fees on that one too. So COVID hasn't really changed the response time per se, but if a landlord is acting ethically, if a process server is acting ethically, if you were substitute served, you'd have 15 court days. But if you're personally served, you have 5. You could almost guarantee that a landlord's also going to be suing all unknown occupants as well, because maybe they don't know who else is in the property. So they have to serve what's called a prejudgment claim at the time that the lawsuit is served, and that could only be done by a registered process server or a deputy sheriff. So, as always, it depends on how you were served, that lawsuit. But if you're ever in a situation where you get a lawsuit, quickly either confer with counsel, do adequate research. Don't let time waste, because that's where you may risk a default being entered. Then once that default's entered, then the burden's on you, the tenant, to file a motion to set aside that default. You would have to attach a declaration as to, you know, there was surprise, excuse, neglect. You'd have to try to convince a judge that there was a good reason why you didn't initially respond to the lawsuit. And as Joe indicated earlier, if you're bringing that type of motion before a certain court, well, you got to know your judge. You got to know how to tailor these arguments pursuant to that judge. And perhaps only attorneys would really routinely know that do this day in and day out. But it's still always very wise to discuss with counsel anytime that you're served with anything. Doesn't even have to be eviction related, right? Trying to think of anything else COVID-wise. You know, the COVID declaration being filed in court, that's one of the recent judicial counsel forms for evictions. The relief from eviction judicial counsel form that's now available, that's where the tenant has qualified for rent relief and they want the judge to stop the eviction. So that is a fill-in-the-blank form to fill out. These aren't made to be complicated or you know, forcing a tenant to have to go retain counsel to do this for them. The courts have drafted these forms to make it as easy as possible for a tenant to fill out to try to get this relief. Trying to just think. Other than that, though, something common that I'm seeing is requesting jury trials. If you are a tenant and you know you want your day in court, but as Joe indicated earlier, the eviction process, the lawsuit process, it is what I call expedited civil procedure, meaning it's expedited lawsuit litigation, because the rules are different for evictions. These laws were written in a way that a landlord could get their day in court much faster than a regular lawsuit, let's say for breach of contract. I handle those cases right now on behalf of commercial landlords where those commercial tenants didn't pay, they vacated, so landlord mitigated their damages, they re-rented it out, and so they're filing a claim for all that lost rent through the contract. But to file that lawsuit, to get your day in court, I think I have a trial date in late 2023 on a case that I just recently filed about 5 months ago. Yeah. So when it comes to evictions, they are being heard much more quickly than that. There are some delays, and the delays will depend on what's going on at that courthouse. If you're up in Barstow Court, for example, and that's for any eviction lawsuit that starts at Hesperia all the way through State Line, Barstow Court is severely behind on processing these lawsuits. It usually takes about 4 to 6 weeks to get that lawsuit back. Once again, that gives the tenant adequate time. So if that eviction is for non-payment of rent, they should seriously be looking into the rent relief if that was the basis of the lawsuit. If it was for some other reason, such as the Category 2, no fault, got to figure out, is it single family, is it multifamily, was there an offer to offer relocation for 1 month or a waiver? It's all about strategizing.
It's huge.
Yeah.
Any other questions we can think of? You can see there's a wealth of information. There's a lot going on. Okay, go ahead. Okay, go ahead.
I don't know if this pertains to this, but I mean, I've been in my place 6 years, and I'm on month to month now. Legally, say for instance, the landlord wanted the apartment back. Do he have the right to do that? I've never done anything. I'm not saying it's gonna happen.
Right.
But I pay my rent either before or on the first.
Mm-hmm.
Could he put me out?
What
If he wanted to, because he wanted to rent to somebody else?
what city's the property located in? San Bernardino County. So to my knowledge, within San Bernardino County, the entire county as a whole, there is no city has enacted any stricter criteria, stricter laws than what the state law is. So this will depend on if you're renting from multifamily or is it single family. Is the dwelling, is it a single family home or is it multifamily? Is it an apartment? It's multifamily. So that is going to be a problem for that landlord because they would have to likely comply with what's called AB 1482. That was the 2019 statewide rent control law that passed that said you couldn't just give a Category 2 termination notice for no reason.
Okay.
Right? So landlord would still need a valid legal reason to terminate, meaning are they getting out of the game altogether? They couldn't just serve that on your unit but no one else. That would be retaliation.
Okay.
And also keep in mind if there's any eviction lawsuit and a tenant is debating what boxes to check as part of that response, that's one of the defenses is retaliation. And if you could adequately show that, Your Honor, I was the only tenant out of this multifamily complex served this termination notice that was supposedly subject to that statewide rent control law, but I'm being singled out here.
Okay.
You would have a really good case to
Okay.
defeat the eviction.
Okay.
Now, if the landlord was renovating all the units, because whatever the landlord has to do for something that's multifamily, they should be doing it for all.
Right.
We both know it's very unlikely that the landlord or someone in their immediate family is moving back in,
Okay.
right, for one unit or for all. It's a matter of, are they getting out of the game altogether, or are they really legitimately doing substantial renovations that would last longer than 30 days to all the units? But now what we're starting to see is, and this will really depend on the city, do they have to pull permits? Do they need to submit plans to the city for approval? So there's extra steps that a landlord has to take when it comes to multifamily such as yours to properly terminate a holdover tenancy. Holdover means month to month, meaning you're not on an active 1-year contract anymore.
Right.
Fixed term. That is expired, so by operation of law, it is month to month.
Right.
But if the landlord came up with a valid reason, it would at least be a 60-day notice. and they would have to either offer relocation or a waiver of 1 month's rent per that notice. But
Okay.
long story short, I don't see a landlord being too successful giving you a termination notice in that situation.
Okay, thank you. I appreciate that.
Yeah.
Thank you.
No problem.
Did you have a question? Anybody else have a question? Okay, well, we're going to make sure we have everybody's contact information. I want to thank Brad, too. I mean, I'm talking about this is some incredible information. Imagine not having an attorney dealing with this right now. There's so many exceptions to so many rules. It's almost like there aren't any rules at all. So, Brad, I appreciate your help, like always, giving us great info. Let's thank Brad
Thank
for
you.
being here.
Thank you.
What we'll do is, there are a couple things we're going to do going away. We're going to make sure that everyone that RSVP'd gets contact information for each and every one of the speakers. We meant to do that last time. I'm not sure we did. As it pertains to potential information that might be good related to what each person spoke about, we'll make sure that that goes to folks that RSVP'd as well. And before long, we expect in a matter of days, the product should be available. The actual entire, everything that you saw today should be available as a on-demand product. So that means you should be able to let folks know that weren't here, that didn't listen to it live. Hey, there's some incredible information on rental assistance. One of the things that came through is, listen, if you owe rent or if you owe on your mortgage and it's COVID related, there is mad relief out there. I mean, that should have came through. LA County folks, you hear Brad talking about it, you know, the landlords can't do anything very quickly. They can't do anything fast, okay? And so it's really, really important. A lot of times when these problems come up, people, kind of like, put their head down the pillow kind of thing, you know what I mean? And you're really penalized for what you don't know and then what you don't act on. You don't know what to do, but figure out what the action items would be based on the situation that you're in. Whether you're talking about landlord-tenant, whether you're talking about owing money on your rent, and there's an argument that it can be COVID related. These are folks, most of the people, now us lawyers aren't necessarily free, even though most of what I do is on a contingency basis, there's money involved. But several of our speakers today offer their services free of charge. They have contracts with state agencies. They have contracts with providers of retirement housing and those types of things that pay them to connect the dots, to help us connect the dots. So I don't think that anyone spoke on any subject today that doesn't touch every one of us in one way, either directly in some way, either directly or indirectly. So there's a lot of information out there, and you really are, even the Bible says, you're destroyed for lack of knowledge, but you're also penalized for what you don't know, okay? So you can't say, oh, I didn't know that this was the law. That's not gonna help you, because if you're potentially getting thrown out of where you live, or you're having this particular situation go on, and if you don't know, and if your landlord doesn't know, by the way, we need good landlords too. If your landlord doesn't know and they don't get it right, it frankly could buy you some time. And so it's really important to pay attention. This whole CALIC series is about providing information and giving you a starting point. In so many of these areas, people don't know where to start. Here's where you start. You can contact any of the people that spoke today, all right? Myself included. That information will still be on the list that we sent out that people RSVP'd from, et cetera. There should be information out there for folks where they can reach out, get info, and again, you're penalized for what you don't know. And there's so much to know out there. Engage professionals that know, engage professionals that are incentivized to help you, and it is really important to give your business or connect with people, professionals that are passionate about what they do and they really want to help people. I think everything you saw today was a helping profession. These are areas where we are actually helping people. We're helping citizens. We're helping landlords. We're helping tenants. We're helping folks that are just affected on the job. So we have to make sure that we do that. So I want to quickly thank everybody that was involved. I want to thank our church, Pastor Oliver, my secret MVP, my sister Kamala Gray back there is a great family law attorney who opened us with the first event. She spoke at the first event after she beat me up. She said, "You know I don't like to speak," and then she spoke. So I'm not going to bring her up today, but I will shout her out. Thank you for your help. And for everyone, the marketing department at McCune Wright, for all of our speakers today, make sure that you do what you need to do to get in contact with us. One of the things that I'll make sure we include, I didn't mention during my speech, is there is a state website where you can get the digital record of your vaccination. For those of you that haven't done that, that's a really good idea. And it should be pretty easy. Most of the time they have the record. It could be just a matter of moments where if you know when you got your vaccinations, you can dial that in, they confirm it, and basically send you an information that can be scanned. I kind of see the vaccination card kind of like the thing that you need to put in the safe and lock away. And if I can use the digital version and put it on my phone, that should usually carry the day with you. So we'll make sure that information is included with all of the other things. All right. So with that said, we want to give everybody good wishes for a great Saturday and great weekend. And for those of us that had got information here because we're in trouble, we're in a bind or whatever else, this is the beginning of the change. That starts off with this is the works portion of faith, right? Faith without works is dead. So, you know, we're believing for things to get better, even if you don't have all the details worked out. But this is the start of the details. Information is power. Take the information, run with it. You guys have a great day. We appreciate you being involved. Thank you.